When making selection decisions, employers sometimes want to consider the backgrounds of applicants and employees. Except for certain restrictions, it's not illegal for an employer to ask questions about an applicant's or employee's background, or to require a background check. However, anytime you use an applicant's or employee's background information to make an employment decision, regardless of how you got that information, you must comply with federal laws that protect applicants and employees from discrimination. That includes discrimination based on race, color, national origin, sex, or religion, disability, genetic information, including family medical history, and age. These laws are enforced by the Equal Employment Opportunity Commission, or EEOC. In addition, when you run background checks through a company in the business of compiling background information, you must comply with the Fair Credit Reporting Act, or FCRA, FCRA. The Federal Trade Commission, or FTC, enforces FCRA. It's also a good idea to review the laws of your state and municipality regarding background reports or information because some states and municipalities regulate the use of information for employment purposes. Before you get background information, you need to understand how the Equal Employment Opportunity Commission, EEOC, and Federal Trade Commission, FTC, impact background checks. First, the Equal Employment Opportunity Commission. In all cases, make sure that you're treating everyone equally. It's illegal to check the background of applicants and employees when the decision is based on a person's race, national origin, color, sex, religion, disability, genetic information, or age. For example, asking only people of a certain race about their financial histories or criminal records is evidence of discrimination. If you get background information, such as a criminal background report, from a company in the business of compiling background information, there are additional procedures that FCRA requires. First, tell the applicant or the employee that you might use the information for decisions about his or her employment. The notice must be in writing and in a standalone format. The notice can't be in an employment application. You can include some minor additional information in the notice, like a brief description of the nature of consumer reports, but only if it doesn't confuse or distract from the notice. If you're asking a company to provide an investigative report, a report used on personal interviews concerning a personal character, reputation, characteristics, and lifestyle, you must also tell the applicant or employee of his or her right to a description of the nature and scope of the investigation. Get the applicant's or employee's written permission to do a background check. This can be part of the document you use to notify the person that you will get the report. If you want the authorization to allow you to get background reports throughout the person's employment, make sure you clearly state it in this check. Certify to the company from whom you're getting the report that you've notified the applicant to get their permission and to get the background report compiled with all of the FCRA requirements, and you won't discriminate against the applicant or employee, or otherwise misuse the information in violation of federal or state equal employment opportunity laws and regulations. Now let's turn to look at how we use background information. When using background check information, again, consider the implications of the EEOC and FTC. Looking to the EEOC, any background information that you receive from any source must not be used to discriminate in violation of federal law. This means you should apply the same standards to everyone, regardless of their race, national origin, color, sex, religion, disability, genetic information, including family medical history, and age. For example, if you don't reject applicants on one ethnicity with certain financial resources or criminal records, you can't reject applicants of other ethnicities because they have the same or similar financial histories or criminal records. Next, take special care when basing employment decisions on background problems that might be more common among people of a certain race, color, national origin, sex, religion, among people who have a disability, or among people who are 40 years of age or older. For example, employers should not use a policy or practice that excludes people with certain criminal records if the policy or practice significantly disadvantages individuals of a particular race, national origin, or another protected characteristic, and does not accurately predict who will be responsible, reliable, or safe as an employee. In legal terms, the policy or practice has a disparate impact and is not job-related and consistent with business necessity. Finally, be prepared to make exceptions for problems revealed during background checks that were caused by a disability. For example, if you are inclined not to hire a person because of a problem caused by a disability, you should allow the person to demonstrate his or her ability to do the job, despite the negative information in your background investigation, unless doing so would cause significant financial or operational difficulty. Now let's turn to the FTC and FERCRA. When taking an adverse action, which means not hiring an applicant or firing an employee, based on background information obtained through a company in the business of compiling background information, the FERCRA has additional requirements. First, before you take adverse employment action, you must give the applicant or employee a notice that includes a copy of the consumer report you filed to make your decision, and a copy of a summary of your rights under the Fair Credit Reporting Act, which you should have received from the company that sold you the report. By giving the person a notice in advance, the person has an opportunity to review and report and explain any negative information. After you take an adverse employment action, you must tell the applicant or employee, orally, in writing, or electronically, that he or she was rejected because of information in the report, the name, the address, the phone number of the company who sold the report, that the company selling the report didn't make the hiring decision and can't give specific reasons for it, and that he or she has the right to dispute the accuracy or completeness of the report and to get an additional free report from the reporting company within 60 days. Now, with this information from both the EEOC and FTC, go out and do great background checks during your selection process.